Hello, I'm Dan Marr from Hamblett Kerrigan in Nashua, New Hampshire. I'm licensed in both New Hampshire and Massachusetts, have been for a number of years. New Hampshire for 35 years, for Massachusetts for 18 years. So during that period of time, I've dealt with a lot of trust and estate matters, litigation primarily, and working with my trust and estates department here at Hamblett Kerrigan here in Nashua. And as such, I've dealt with a lot of revocable trusts. Revocable trusts are a wonderful estate planning measure upon which you can take your assets and put them into a trust. And since it's revocable, during your lifetime when you're still mentally competent, you can make whatever decisions you want. You can treat it just like a will, but it avoids probate. It avoids perhaps your neighbors finding out a little bit what's going on by the probate process. But also what it does is it allows the trustee of the trust to give immediate access to your beneficiaries of the assets without going through the protocols of all the court process. So you don't have to wait for that. And you can make sure your debts are paid off quickly, as well as making sure that distributions go. Revocable trusts are also a wonderful measure for you to be able to not give your 18-year-old child, when they turn 18, all the money. You can stagger it out over a period of time. You can make it irrevocable on your death. So it's a wonderful mechanism, and I've talked about this in other vlogs, and I'll do that in future vlogs. But I'm going to talk today about some of the mistakes you make in revocable trust. Wonderful idea for the revocable trust, but try to avoid these mistakes. One, and first off, is you do the revocable trust. You go to your attorney, or you get it online. Online, there's some risks involved in that. But if you do that and you sign the declaration of trust, the trust document, you do all that, you sign a will that pours everything that you forget to put into the trust, and then you anticipate that there's the real estate that you have other investments and the like, but you don't turn over and fund that trust by actually going to Charles Schwab or to Fidelity or wherever your investment accounts are and make those accounts now in the trust name. The bank account's same thing. You don't do that. You don't take your property and deed it from 1 Main Street in Nashua, New Hampshire, transferred over from John Smith over to the John Smith Revocable Trust of 2024. You don't do that. So therefore, there's a document there, the revocable trust, that's useless other than the fact that there's a will that pours everything into it. And the will has to go through probate. So you've missed a lot of the opportunity that you have for a revocable trust by not funding that trust. You have to take those assets and put them into the trust itself. So signing the documents and saying, "Oh, I'm done, I'm all set, I don't have to do anything else." No, you have to still do the deeds. You got to go over to the financial institutions, the investment accounts, and transfer them over. It's not that big a hassle, but it's well spent time to do it. It takes some time, a little bit of time, but it's well worth it, because later on you're saving your heirs a lot of headaches in the future. So please fund the trust. Successor trustees, you got to make sure that when you're alive, of course, and you're competent, you are making the decisions for the trust and you can revoke it. But once you are incapacitated, one of the things you want to do is most of our clients want to say, if I get a guardian for some reason over me, that guardian can't change my trust. I know what I'm doing when I write this trust, and somebody else can't change who the beneficiaries are or anything else like that. You probably want to put that provision in there so that guardians can't change it before you die. And then you also want to pick somebody that's going to be a successor. You want somebody that's good with finances, and also somebody that can actually act as a proper fiduciary for your other beneficiaries. You don't want your son who's really good at finances that hates his other brother or sister that he thinks is a ne'er-do-well. If you want both of them to be treated equally as beneficiaries, or you have your set aside and you want to make sure that that trustee is going to act as a fiduciary, you want to pick somebody that can actually follow your instructions in the trust and act like a fiduciary. And we've talked about that. I've talked about that in another vlog as to when you should not be a fiduciary. So you want to pick the right successor trustee. That's the second part. So not funding the trust, not picking the right successor trustee is another critical issue. One of the things I see sometimes in these trusts, more along the lines where somebody gets online, off the internet versus a good competent lawyer doing it is they don't explain what happens on death. How quick do you have to resolve the matters and the assets? Do you have to gather all the assets up and sell them all, or you're deeding one property, my example, 1 Main Street over to somebody else? All that should be planned out and specifically spelled out into the agreement, and you want to deal with that so that they know when they're supposed to do something when you die and how quick, so it's just not languishing out there, and then what they're supposed to be doing. So spell that all out there. Last thing to consider, I've talked about this in other vlogs as to what they are, is something called an interim or no contest clause. Do you think that somebody might be fighting about this? If you want to put a provision in that says if you fight about this and you lose, you challenge my mental competency at the time I entered this trust, or said I was unduly influenced, and you're unsuccessful at that, you get nothing. You basically are treated like you predeceased me, is generally what you do. You want to consider that. You don't have to do that, but you want to consider that as an option for you if you want to avoid some controversy after you die, because sometimes you can't unbreak that egg. When one sibling says something to another after you die, they can't take it back. And if they're thinking about it, but it doesn't leave their lips, or it doesn't leave their texts or pleadings in a lawsuit, they can change that opinion of theirs, rather than when they say it, they can't take it back. So things to consider. I'm Dan Marr at Hamblett Kerrigan. Our telephone number is 603-883-5501 here in Nashua. Or you can check out our website, which is nationallaw.com. That's nationallaw.com. And our blogs are on there, as well as a lot of other useful information. I look forward to the opportunity to work with you if the opportunity still arises. Thank you.